When does child support end? Navigating child support obligations can be one of the most challenging aspects of divorce or separation. The financial contributions made by the non-custodial parent to the custodial parent often serve as an essential lifeline for the child's well-being, covering costs like healthcare, education, and basic needs. However, child support isn't intended to last forever, and many parents find themselves wondering, when does child support end? The answer can vary significantly depending on numerous factors, such as jurisdiction, the child's needs, and any special circumstances that may apply. Child support duration in New York. In New York, child support is mandated by law and typically lasts until the child reaches the age of majority. This requirement is based on the legal principle that both parents are responsible for the financial well-being of their children. The goal is to ensure that the child's needs are met, including housing, food, healthcare, education, and other necessary expenses. Child support until age of majority. New York differs from many other states in that the age of majority for child support purposes is 21, not 18. Exceptions to age of majority. While 21 is the standard age for the termination of child support in New York, there are exceptions to this rule. These exceptions can end child support obligations before the child turns 21 or, conversely, extend them beyond this age. 1. Child's emancipation. 2. Child's marriage. 3. Child's entry into the military. Termination of child support for special needs children. For children with special needs, the requirement to provide child support may extend beyond the age of 21. Modifying child support. Child support is not always a fixed amount that remains the same from the time it is initially set until the child reaches the age of majority. There are circumstances where child support can, and should, be modified to reflect the current situation more accurately. In New York, as in many other states, a parent can request a modification of the child support order if there has been a substantial change in circumstances. Circumstances requiring modification. There are several situations that can warrant a modification of the child support agreement. These are generally significant changes that impact the financial needs of the child or the paying parent's ability to pay. Here are some of the most common situations. Change in income. One of the most common reasons for a modification is a substantial change in either parent's income. This could be due to a job loss, a significant pay decrease, or increase in income of at least 15% or more. 3 years have passed. 3 years after the initial order, last modification, or adjustment, either parent can initiate a modification request, allowing the court to consider changes in circumstances that may warrant an adjustment, be it an increase or decrease in child support. This flexibility in the system ensures that the child's well-being remains a top priority as financial situations evolve. Change in custodial arrangement. Another situation that might necessitate a modification of child support is a change in the custodial arrangement. If the non-custodial parent assumes more custody or the child begins to live with them full-time, This could constitute a substantial change warranting a reduction in child support. Change in child's needs. Lastly, a significant change in the child's needs might also justify a modification in child support. This could be due to increased medical expenses, educational costs, or even changes in the cost of living. How to request a modification? Requesting a modification in child support can be a complex process, and it's essential to follow the appropriate steps. Here are some general steps to follow. 1. Identify a significant change. 2. Gather documentation. 3. File a petition. 4. Attend a hearing. 5. Wait for a decision. Enforcement of child support termination. Child support is a legal obligation, and failing to meet it can have serious consequences. The termination of child support, whether due to the child reaching the age of majority, a change in custody, or other reasons, is not automatic. It often requires action by the parent or, in some cases, enforcement by the state. Let's explore the role of the Child Support Enforcement Unit and some of the legal remedies for non-payment of child support. Role of the Office of Child Support Enforcement. In New York, the Office of Child Support Enforcement, OCSE, plays a crucial role in ensuring that child support obligations are met. The OCSE is responsible for collecting and distributing child support payments. They also have the authority to enforce child support orders when non-custodial parents fail to pay. Legal remedies for non-payment. When a non-custodial parent fails to meet their child support obligations, there are several legal remedies that can be pursued. These can include wage garnishment, liens and seizures, and contempt of court charges. Wage garnishment. Wage garnishment is one of the most common methods used to collect child support. If a non-custodial parent is employed, the OCSE can order the employer to deduct child support directly from the parent's paycheck. This ensures that child support is paid regularly and reduces the chance of non-payment. Once a child support order is terminated, the wage garnishment order should also be terminated. Liens and seizures. If a non-custodial parent has outstanding child support debt, the OCSE can place a lien on their property. This can include real estate, vehicles, and other personal property. If the debt remains unpaid, the property can be seized and sold to satisfy the debt. Additionally, the OCSE can seize bank accounts or intercept tax refunds to collect unpaid child support. Contempt of court. In cases where a non-custodial parent continuously fails to pay child support, they can be held in contempt of court. Contempt charges can result in fines or even jail time. The goal of these charges is not to punish the parent, but to compel them to meet their child support obligations. However, once a child support order is terminated, the parent cannot be held in contempt for failure to pay future support, although they can still be held accountable for past due amounts. Preparing for child support termination. The termination of child support is a significant event that requires careful preparation and planning. It's not just a matter of ceasing payments. Many factors need to be considered to ensure a smooth transition for all involved parties. This includes planning for the transition, seeking legal advice, preparing necessary documentation, and maintaining open communication with the other parent. Planning for the transition. The termination of child support can have a substantial impact on the financial situation of both the custodial parent and the child. It's essential to start planning for this transition well in advance. 1. Budgeting. 2. Education planning. 3. Insurance and medical expenses. Legal assistance and documentation. Navigating child support termination can be complex, and it's often beneficial to seek legal advice. 1. Consulting with a lawyer. 2. Preparing documentation. 3. Filing a motion. Call us today at 212-537-5859 to schedule a consultation.